Good afternoon, everyone. Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Good afternoon, Judge Mincy. Whenever you're ready,
All right, good afternoon.
we're going to start with these first two and then bring everybody else out.
Okay. All right, I will go ahead and get us started. Ladies and gentlemen, good afternoon. I'm Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this junction. I'm going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. I want to also remind the defendants that you have certain constitutional rights. The first one being that you have a right to have an attorney to represent you at this stage of your case or whenever you need the attorney for your whole case. Most of you at this point know who your attorney is, and if not, you've hired a private counsel. I also want you to know, as defendants, you have a right to remain silent. Anything that you say about the facts, the circumstances, or the occurrences of your case at this point, you need to govern yourselves accordingly, listen to your lawyers, and make sure that you don't say anything that may be against your interest to be used at a later date. All right, we are in courtroom 2. Who do we have?
Position 11, Wilson.
All right, that's Michael Wilson, 22 CR 00646 There are 4 charges: DUI, driving under the influence of multiple substances, illegal stop, stand, or park where prohibited, another DUI less safe, and driving an expired or no license plate or decal. Pre-trial.
This is 4th arrest. Last was 2017, possession of a Schedule 2 controlled substance, sale of marijuana, misdemeanor possession of marijuana. He got first offender for those, 2012 probation, and a 2011 suspended license. That's all.
All right, state, who do we have?
Good afternoon, Judge. How are you?
I'm fine. How are you, Mr. Rhodes?
I'm doing pretty good. Long time no see. Good to see you.
I agree, yes.
As it relates to this case, Your Honor, the brief facts related to it is that on September 22nd, 2022, around 1 p.m., the defendant was found asleep in his car. He was stopped in the roadway at the intersection of Jones Bridge Road and Sargent Road. His vehicle had a tag that was expired from July 19, 2022. After officers awoke the defendant, he exited the vehicle and officers smelled the odor of an alcoholic beverage on his breath, and the defendant did have bloodshot and watery eyes. He showed signs of impairment, and on the field sobriety test, they were positive on the alcohol sensor. As already indicated, this particular defendant has 3 cycles on his GCIC. Defendant did complete first offender for drugs not in container in 2020, and the defendant currently has a $13,500 surety bond, $10,000 on a DUI, $2,000 on a tag, and $1.5 for illegal parking. At this time, we would want to reduce that bond, $7,000 split bond, $3,000 surety bond on the DUI drug, and then $3,000 signature bond on the DUI alcohol, $500 surety on the expired tag, and 500 surety on the illegal part. No alcohol or drugs, and no driving without a valid license and tag. So I believe that that's a total of 3,500 surety and 3,500 signature bond, sign-on bond, Your Honor.
All right, let me make sure I got my math correct here. Okay, I think I'm with you. So I have, hold on, maybe I'm not. So the state's recommendation for the 7,000 split is 3,000 on the DUI surety, illegal stock 500 surety, DUI less safe 3,000 SOB,
That's correct, Your Honor.
and then 500 on the license tag.
Yes, ma'am.
And that's a surety. Okay, maybe I wasn't too bad off. Okay, sounds good. When you do too much math, it gets me. But all right, let's see, Ms. Kim, this is your case?
Yes, Your Honor. Mr. Wilson is 34 years old, Your Honor, and he has been here in Georgia almost 30 years. He has his family members, their parents, siblings, uncle and auntie. He has a strong ties to community. And yet he has been truck driver, and he's afraid that he's no longer employed because of this incident. He may lose his job. He graduated from high school, and we would like to request for actually signature on bond. He was real recommended, and we believe he may be qualified for that. And yet, if Your Honor is not inclined to give him a signature on bond, we would like to request that surety bond would be maximum $2,000, so that way he can be able to get some bond paid. Thank you.
All right, is he an independent truck driver, or he works for the company?
He worked for JES company, and he's afraid that this is going to cause serious trouble.
No. I'm sure that it will. The state has recommended a $7,000 split bond, and I'm inclined to agree with that split bond, which will be $4,000 surety and a $3,000 signature. And do you have that, Ms. Grace?
I
Okay,
think it was $3,500 surety and then $3,500 signature.
Yes, Your Honor. Let me apologize. It was
Yeah.
3,500 and 3,500.
oh, even, okay, 3,500, okay. So that is fine, I will go with that, counsel. So that's 3,500 surety on the first two charges. And then on the second DUI, let's say, 3,000 signature, and on the expired or no license plate, 500 signature. So half and half, 3,500 surety, 3,500 signature. And again, no drugs, alcohol, or weapons while on bond, and no driving without a valid Georgia driver's license. Anything else?
No, thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. What do we have next, Deputy?
Position 3, Brown.
Okay. This is 22 CR 006454E, Ronnie Brown. Your charge is 1 count of theft by shoplifting, 2nd count of criminal trespass, both with the offense date of September 22nd, 2022. Pretrial?
14 total between Louisiana, Texas, and Georgia. Last arrest was on the 3rd of this month for shoplifting. The 1st of this month for shoplifting. He went to the city jail for both. I'm gonna go to Louisiana next. Last arrest there, January of this year, domestic abuse battery, simple criminal damage to property, violation of protection order. 2021, domestic abuse, ag assault, battery of a dating partner, and theft. 2018, fugitive from justice arrest. 2018, That's a disposition. Disregard that one. 2009 reckless operation, hit and run, driver not licensed. Vehicle must use lighted lamps, illegal possession of stolen things, resisting an officer. Last arrest in Texas was in 2008. That's it.
All right. ASG Duncan.
Good afternoon, Your Honor. In addition to what pretrial has stated, I did note that on the record, it did indicate that he is still currently actively outstandingly wanted out of New Orleans for domestic abuse. In this case, though, in particular, it happened yesterday, September 22nd, 2022, at the Walmart located at 835 Martin Luther King Jr. Drive in Atlanta. The defendant was observed by loss prevention associates at the store, James Desmond, on video surveillance, going throughout the store, putting clothes into two children's book bags, which he also had not paid for. The loss prevention associate was able to identify him because he had been trespassed from that location and arrested several times for shoplifting. And this state's contention that those city jail cases may be related to this Walmart as well. Walmart did indicate that he has had arrests from their location specifically several times and has been told on several occasions not to come back. He continues to come back and to ignore the order of the court or the orders of the officers who have warned him. And in this particular instance, they were watching him and he did in fact proceed past all points of sale with those items without any intention to pay and was stopped by loss prevention, and the items were returned. Given this facts and circumstances in this case, we do have a concern about the risk of reoffense, Your Honor. In this month alone, he's been arrested for shoplifting. This will be the third time, and Walmart has indicated that they're going to pursue every instance of shoplifting that they've encountered this defendant for, because he is continuing to come back to their location after being told not to come. We do have some concern about flight risks. The defendant is currently wanted. Therefore, there's a preset bond in this case of $1,000 surety, $1,000 surety per count, and the state is going to be asking that remain as set, and the state believes that is more than reasonable. In addition to the recommendation to stay away from that Walmart on Martin Luther King Jr. Drive, no alcohol, drugs, and weapons, and nothing further, no further violations of Georgia law, and nothing further from the state.
All right, thank you. PD Gant.
Good afternoon, Your Honor. Mr. Ronnie Brown is 30 years old. He has been in the Atlanta, Georgia area for about 4 months. He does not have any family here, nor does he have anyone to help him make bond. He is the proud father of a 3-year-old. We are unopposed to the stay away at the incident location. Mr. Brown does not have any reason to return there. He completed 10th grade. He is unemployed at this time, and he strongly denies the allegations. And despite my client's history, Your Honor, I did not hear about any recent convictions for theft. He is certainly presumed innocent in this and any open cases. I'm requesting a signature bond, as he does not have the means to pay anything toward bond. And if Your Honor determines that he is ineligible, then a bond reduction, no more than 1,000 total, and that would be 500 for each count. Thank you, Your Honor.
All right. I will order that we continue with the $2,000 surety bond, $1,000 on each charge. No drugs, alcohol, or weapons while on bond. Stay away from the Walmart at 835 Martin Luther King Drive. And I believe that will be it. Anything else, counsel, that I need to take up?
Nothing further from the state.
Nor from the defense. Thank you, Your Honor.
Thank you.
They didn't hear their announcements. Did you give them their announcements as well?
Okay. All right, good afternoon. I'm Judge Regina Mincy, and this is the state, excuse me, this is the Fulton County State Court Expedited Accusations calendar. This is a calendar for cases that have been recently arrested and charged with certain misdemeanor offenses. Soon after the individual's arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. This is usually the defendant's first or initial appearance before a state court judge, so we're able to address bond and other matters that may be appropriate for the case. I'm going to begin by advising everyone that this entire proceeding is being recorded as well as live streamed on YouTube. You have a right to have an attorney present to represent you at these proceedings, and you also have a constitutional right to not make any statements against your interest, and you should remain silent, because anything that you state regarding the facts of the circumstances or occurrences of your case can and will be used against you. So listen to your attorneys and govern yourselves accordingly. All right. First case, or third case.
This is position 1, Mr. Brown, Brandon Brown.
Okay. All right, this is case number 22 CR 006452G. Brandon Brown, you're charged with 1 count of simple battery. The offense date is September 22nd, 2022. Pretrial.
This 12th arrest. Last arrest was in July. Felony theft by receiving. Case number 22 CP 20210-612.
Who's speaking?
I don't know, but 2018 failure to appear, driving without a valid license, obstruction, suspended license. 2015, he got first offender for reckless conduct, false statements or writings. 2015 failure to appear. 2013 misdemeanor, theft by taking conviction. 2011 burglary. I think it might have been reduced to trespass conviction. Before that was 09 criminal damage to property, obstruction. That's it.
All right. Ms. Duncan.
Yes, Your Honor, just to note for the record, this is a cross-defendant case with position 1. So the facts are the same for both of the cases.
This is position 1.
I'm sorry, position 2.
Okay. All right. Gotcha.
So in this incident, it did occur yesterday on September 22nd, 2022 at 339 Autumn Lane Southwest. The defendant in this case is accused of punching and pushing his brother, the victim in this case, Mr. Corey Brown, both common spelling. The state does have some concern about the risk of reoffense in this case, as well as a possible flight risk, given that there is a somewhat recent FTA. This defendant does have an open case. However, there may be some other issues going on with this case that the state needs more time to investigate. The state is going to be requesting a $3,000 signature bond through pretrial services with no further contact with the victim in this case. The warrants did indicate that they live at the same location, so the state is willing to defer to the court as far as the stay away provision. We're going to ask for 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right.
And because of his history, we would prefer that he be monitored if the judge is so inclined.
All right, Ms. Gant.
Thank you, Your Honor. We are unopposed to the state's recommendations for the signature bond. My client informs me that he will in fact be vacating the residence at the incident location. So we are in agreement with the one-time law enforcement escort so that he may retrieve his belongings. Mr. Brown is 31 years old. He has been in the Atlanta area for 31 years. He is the proud father of 5 children. He is paying child support. His children's ages are 13, 10, 9, 4, and 2. Mr. Brown has a GED. He is employed at Ultra Towing and has been so for the past 2 years. He denies the allegations, specifically denies being the primary aggressor, but he wants contact with his brother, Your Honor. And if we would ask that if Mr. Corey Brown, his cross-defendant, wants contact, we would ask that the court allow that he have no violent contact with his brother. Thank you, Your Honor.
You stated that they do reside together.
Yes, Your Honor, but Mr. Brandon is moving.
Your Honor, I represent Mr. Corey Brown, and he tells me that his brother is moving. He confirms that, Your Honor.
Okay, good. Thank you, Ms. McLeod. All right. I was going to hear the other case, but I'll go ahead and roll on this one. I'm going to grant the $3,000 signature bond through pretrial. I'm going to order a stay away from 339 Autumn Lane, Southwest. I'm going to order no further contact with the victim, Corey Brown. This incident just happened. We haven't had a cooling off period. Not too sure what's going on, but right now I want the parties to stay away from each other and have no further contact. No drugs, alcohol, or weapons while on bond. 1-day anger awareness course. And as far as the monitoring pretrial, I don't think there's anything special that I need to say, is it?
Say that again?
And the state asked for to make sure that there was going to be some monitoring. And I don't think that I need to ask for anything specific.
I mean, it's per judge, per state. So,
And so that would be extra monitoring and reporting in. Is that what the state is asking for?
No, Your Honor, to clarify, the state was aware that he is not necessarily recommended for pretrial. However, we would like his signature to be through pretrial per the judge. That was why we requested the monitoring.
Oh, okay. Okay. Well, I, per judge, am ordering that you receive the signature bond through pretrial.
And Your Honor, the one-time law enforcement escort to retrieve his belongings.
All right, one-time law enforcement escort to retrieve any personal belongings. Mr. Brown, do not go back to the home or your location without your police escort, else you can be arrested. So when you get out on the signature bond, you must arrange with the law enforcement in order to go back to the home to get your belongings. Do not go back there alone, okay?
yes, ma'am.
All right, good luck to you.
Thank you.
Thank you,
Position
Your Honor.
2, Corey Brown.
All right, this is case number 22 CR 006453G. Corey Brown, you're charged with 1 count of simple battery, offense date 9/22/2022. Pretrial.
20 total. Last arrest was in February. Ag assault, theft by taking. That's open. 22 CP 206-531. Got another open case. Possession of amphetamine with intent. Trafficking heroin. Possession of marijuana with intent. Sale of MDMA. 2 counts of possession of a controlled substance. 1 or 2 with intent. Possession of a Schedule 4. It's 21 CP 201-476. Also got an open case, simple battery, felony terrorist threats. That's simple battery against police. 22 SC 180238. In 2015, they gave him 5 years to serve, 5-year probation for ag battery. It's 13 SC 118559. 2013 felony obstruction, possession of a firearm by convicted felon conviction. 2012 possession of a firearm by convicted felon, simple battery conviction. I'll leave it at that. He wasn't recommended due to the open case and the probation.
Mhm. Okay. All right. I'm sorry.
Yes, Your Honor, the facts remain as previously stated on the record in position 1. The state has a concern in this case about the risk of reoffense, given this defendant's history and our concerns about the risk of reoffense. In this case, the state is going to be requesting a $3,000 surety. no further contact with the victim in this case, which is Brandon Brown, both common spelling, will defer to the court for the terms of the stay away. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. I do want to make it clear for the record and the court that this defendant is being referred to MHC. And he's being referred, but we need to contact the victim after he's released in order to complete the referral process, which is why we recommend the signature bond on position 1. Nothing further from the state.
All right. McLeod?
Yes, Your Honor, my client is 32 years old. He has been living in the Atlanta area all his life. He is the father of 2 children, a 1-year-old and a 3-year-old. Both children currently reside with him. His mother also lives in the location that was mentioned earlier, Your Honor. My client tells me that he regrets this disagreement that he had with his brother. He does want to have contact with his brother because he says they have already resolved the disagreement that they had, Your Honor. So he does not want to stay away. He does want contact, and it seems that his brother also does want contact based on what was stated earlier by Ms. Gant. I do acknowledge that my client has some history, Your Honor, but even though he's employed, he does not make a lot of money, and he does have 2 small children that he has to support. I would ask the court to take that into consideration in setting his bond, and his brother did receive a signature bond, Your Honor, so I would ask the court, even though he does have some history, to give him a signature bond since they don't seem to be at disputes with each other right now, Your Honor, and the issue has been resolved. Thank you, Your Honor.
And the state will be opposed to the signature in this case, given this defendant's extensive violent history. Nothing further.
All right, I'm going to order the $3,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order no further contact with the code or cross defendant, Mr. Brandon Brown. And I guess that, with him being there, I just want to make sure with Corey Brown, if you return to that location and make bond, that Brandon Brown will not be residing there. I think I've heard that. So just want to make sure that there is a no further contact with your brother Brandon Brown. So he should be gone hopefully by the time we get there. He has moved. If he has not moved, they need to govern accordingly and not go there until he has moved out. Is that clear?
Yes,
Yes,
ma'am.
Your Honor.
All right, that should conclude this case.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, no further contact, correct? Mhm. Sorry about that. Go ahead.
This is position 7, Griggs.
All right, 7 and 8, deputy.
I'm sorry, Judge.
You said 7 and 8?
No, this is position 7. Let me see. Is he position 8?
Oh, 7, Jason Wade.
Yes,
Jason Wade Griggs, I'm sorry.
it's okay.
All right, this is case number 22 CR 006457D. Jason Griggs, who charges 1 count of battery, family violence, and a 2nd count of hindering a person making an emergency telephone call. The offense date is 9/21/2022. Pre-trial.
36 total between Georgia and Tennessee. Last arrest was 2019, possession of meth. He's on probation in Gwinnett, possession of meth, possession of a firearm during the commission. 2020, they gave him 5 years probation. Got another possession of meth out of Gwinnett, 10 years probation for that. Hold on, Judge. With the 2018 possession of meth, he was also found guilty of tampering with evidence, possession of a knife or a firearm during the commission, 2 counts. He had a battery DV that was amended in 2018. It was accused out of Gwinnett, not sure the disposition. 2018 probation violation, another 2018 probation, 2015, 2013 probation, 2013 felony obstruction conviction, along with criminal trespass, 2011 felony obstruction conviction, 2010 probation, 2009 financial transaction card fraud, 2 counts conviction. And he had a stalking that was dismissed from 08 out of Gwinnett. That's it.
Okay. DSG Rhodes?
Yes, Your Honor. As it relates to Mr. Griggs, the brief facts are that on September 21st of 22 at 11:30 p.m. at 365 Morning Dew Circle in Roswell, there was a 911 call that was received. They were unable to get through, however, because the response was cut off abruptly. Officers did make contact, however, with Christina Nichols, who they observed bleeding and had laceration on her wrist. Ms. Nichols stated that the defendant grabbed her by the wrist and twisted it, and that the laceration was caused by the defendant's fingernails. Ms. Nichols indicated that he also threw her phone in the bushes. The defendant himself stated that they lived together for approximately 2 years and that he had clothes in the house. And the defendant was observed to be visibly intoxicated on this night. As already indicated, the defendant does have 35 cycles. The convictions that were highlighted in the last 10 years include the felony obstruction and criminal trespass in Gwinnett County in 2014, VGCSA and possession of firearm and tampering with evidence just as recent as 2020 in Gwinnett, theft by shoplifting in 2019 in Duluth, and the possession of meth in 2020 in Gwinnett. Your Honor, I would also highlight that there was 2013, 2015, and 2018 probation violations and a failure to appear in 2019. Defendant was arrested for family violence battery in 2018. However, that charge was dismissed. What we're asking for in this case, given the defendant's criminal history, is a $5,000 surety bond, a stay away from 365 Morning Dew Circle, no further contact with the victim in this case, Miss Christina Nichols, and that's Nichols, no alcohol, drug, or weapons, 1 day anger management awareness. We do believe that this particular defendant poses a risk to reoffend and possibly intimidate the witness/victim in this case. And again, that breakdown is 3,000 and 2,000, Your Honor. Thank you.
All right, thank you. PD Kim?
Yes, Your Honor. Jason Griggs is 43 years old, and he has been here in Georgia for all his life. And he has family members, parents, and siblings. He's self-employed as a handyman, construction. He does home solution, Sweetwater. He has been doing that for about 1.5 years. He graduated from high school and he has some college. He has ties to the communities and he's not a flight risk. And we believe that we would like to request for signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond, because of all the histories, we would like to request for maximum $2,000, $1,000 per each. good bond. Thank you very much.
All right, I'm going to enter an order for a $5,000 surety bond, and that'll be 2,500 on each. I'm going to order that there be a stay away from 365 Morning Dew Circle. I'm going to order that there be no further contact with the victim, Christina Nichols, and no drugs, alcohol, or weapons while on bond. And I will not order the course at this point. And I think that will be it, counsel. Anything else?
No, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Position 10, Simon.
And after position 10, we have position number 6.
Ernest Simon, 35 total. Last arrest was 2017, failure to appear. Hold on. All right, yeah, failure to appear. Underlying charges, cruelty in the third, battery DV, simple battery DV, false imprisonment. 2014, probation violations for obstruction, battery. Got a 2012 battery obstruction. That's where he pled NOLO to. He went to felony earlier and got no bond for whatever his charges are. 2011 probation violation for simple battery. 2009 probation. Yeah, that's it.
Your Honor, if I may, the defendant in this case was observed driving without a seatbelt on September 22nd of 2022. When the defendant's information was ran, it came back that his license was suspended for failure to appear, which was issued back June 17th of 2005. And the defendant was also wanted for a DV simple battery. The simple battery charge was actually upgraded to the Superior Court as a felony family violence battery. As indicated, he does have 35 cycles. He does not have any driving violations in the past 10 years. And there was a 2014 probation violation and a 2017 failure to appear in Fulton. I believe the defendant currently has a $1,500 surety bond. We're asking that Your Honor make that $1,500 a signature bond, a sign-on bond, 1,000 signature on the suspended license, and 500 signature bond on the seatbelt. We just ask that conditions be imposed that he does not drive without a valid license and no alcohol, drugs, and weapons. Thank you, Your Honor.
Your Honor, we are not opposed to the signature bond at this time. My client is 55 years old. He does have 2 young children, a 5-year-old and a 12-year-old that live with him. He's taking care of those children, and he is employed and a native of Atlanta. So based on that, I would say he's not a flight risk.
Your Honor, I believe you're on mute. I'm sorry.
Thank you. Sorry about that. I will order that $1,500 signature bond That would be 1,000 on the driving unsuspended license and 500 on the seatbelt violation for a total of 1,500. I'm going to order no driving without a valid driver's license and no drugs, alcohol, or weapons while on bond.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, I'm sorry, I did not say whether it was pretrial or through the jail. That would be through the jail. Signature bond through the jail.
Position number 6, Your Honor.
I forgot you. Go ahead, Milton.
Thank you, guys.
This is 22 CR 0064662C. This is Debana, is it Debana Glover? You're charged with 1 count of battery family violence. The offense date is 9/21/2022. Pre-trial.
Second arrest, 2012, trespass. It was non-process.
All right. ASG Duncan.
Yes, John, this incident did occur on September 21st, 2022 at 7920 Senoia Road. It looks like at that location is a Marco's Pizza and a Starbucks. We're not necessarily sure which one. However, in this instance, the defendant attacked the victim, in this case, Miss Taylor Thomas, both common spelling, when she went to that location to get her house keys and her, so that she could get her dog from her ex, the defendant in this case. The victim did state that they are no longer in a relationship and they no longer live together. But she wanted the house keys back. And while she was waiting outside, she was surprised attacked by the defendant in this case. The facts indicate that there was a verbal altercation that turned physical, where the defendant in this case struck Ms. Thomas in her face with her fist, causing visible marks, and slammed the car door on her legs several times. The incident was caught on the surveillance camera by the neighboring business, one of which I already listed on the record. And then there was an additional corroboration of the events that had occurred. There was a witness, a Miss Bernice Cooper, who advised officers on scene that she had to intervene in the altercation and pull the defendant off of the victim. As stated before, these parties were in a relationship and did live together at one point. Here we have a concern about the risk of offense if there is no further contact granted. And we also have a concern about intimidation of the witness, given that there is and was some sort of relationship here, and given that when it was ended, it became violent. We do have some concerns about the specific victim in this case. Given the violence and the nature of the offenses alleged, as well as the other factors that the state believes is present in this case, we are requesting a $3,500 surety. No further contact with the victim. The victim also requests that she stay away from her address. I will put that in the chat to the defense and to the court. On 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Your Honor, my client is 28 years old. She has some college education. She is currently employed as a barista at Starbucks. She and the complaining witness do not live together. As a matter of fact, the complaining witness is a resident of the state of South Carolina, so she does not even live in the state of Georgia. My client is okay with no further contact with the complaining witness, Your Honor. My client states that the complaining witness came all the way from South Carolina to her job and confronted her at her job. And the result was this incident, which of course my client regrets. Based on the fact that my client has no history at all, Your Honor, I would ask the court to give her a signature bond. She does not wish any further contact with the alleged victim, and they don't live together anymore. They don't reside in the same state, so there's no problem with in terms of contact, Your Honor. Nothing further.
All right.
And to whom would Your Honor like me to send the address for?
Melissa Grace.
Okay.
All right, I'm going to grant a $5,500 signature bond through pretrial. I'm going to order no further contact with the victim, Taylor Thomas. And we will put the stay away location in the order. Because you don't need to say to stay away from, I guess, the Marcos and Starbucks on Sonoya Road. That was just the incident location. Is that correct?
Correct.
Yes, Your Honor. My client actually works there, so
Oh,
it would
she
mean
works
she
there.
could not go to work. Yes, she does.
All right. We won't order a stay away from the incident location, but as far as the stay away, it would be Miss Taylor Thomas's personal address that we'll order the stay away from. Is that what we're doing?
Correct.
Okay. No drugs, alcohol, or weapons while on bond, Ms. Glover. And I will order the one-day anger awareness course through pretrial. All right, anything else council need to take up?
The state would just like to note its objection to the signature bond and the battery family violence where injuries are alleged. Nothing further.
All right, thank you.
Thank you, Your Honor.
Mhm.
Your Honor,
Yes.
my name is Taylor Thomas and I'm the victim. I would like to request a restraining order because this is not the first time that.
Hold on a
Miss-
second. Hold on 1 second. In order to speak with me, I have to see you on camera.
It says my camera is disabled.
And are you the victim in this case with Debana Glover?
Yes, ma'am, I am.
Okay, and what is your name?
Taylor Thomas.
Okay, because it says a different name.
Sorry, that's just my iPhone name.
Okay. And I apologize that I did not know that you were on the call, mainly because the name did not match up before I made my ruling. But I will allow you to address the court. I need to swear you in if you want to do that.
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell Ms. Taylor, Ms. Thomas?
I would like to get an additional restraining order. Throughout the relationship, we were together for 2 years, and this is
Your
not the
Honor, I
first.
would object to this line of
This is
testimony
not
by
the
the
first
victim.
incident that
And
I've
the
been
court has
hold on,
already
hold on.
ruled.
Right, hold on, Ms. Thomas.
Yeah, the court has already ruled, and this is, if she wants a restraining order, there's a procedure for that.
And the state would argue that her testimony is relevant to the Ayala factors, and it's in Your Honor's purview to reconsider. It is up to her to decide that at this time.
Right, I will inform you, Ms. Thomas, I was going to let you speak to this incident. If you need other assistance, there's a victim witness advocate with the solicitor's office that could give you more information and assist you with that. That is not something that this court, I myself can rule on today. But I have given the ruling regarding the bond. And if she violates that bond or comes around you, if you see her, you need to call the police. If she is, I guess, in your space or around you. But any other assistance that you may need for your protection, there is someone, and have you spoke with the advocate at the Solicitor's Office?
Yes, ma'am, she had called me. I'm just stating my concern because I do have family and friends in Atlanta and I travel for work. I just want to say I have no reason to be in the area where her mother lives and her job. It's just more so of when I go to the city, if we run into each other because we both are in a community. So I just wanted to state that's why I would like to reach out further to
Well, let me
for
say this.
safety measures.
Right, for safety measures, all I can do today at this bond hearing, which I have checked on the order, is that defendant should have no contact directly or indirectly with any victim or the victim's family members, professional, personal, or close associates, whether by phone, mail, email, pager, or any writing, signed note or message. If the defendant encounters any victim, the defendant must immediately leave the area and remain at least 200 yards away from any victim. So she is to not have any contact with your family members, your friends, whether you have the mutual. And again, Ms. Glover, you understand that you're not to be within 200 yards of the victim. Is that correct? You understand that?
Yes.
Okay.
And Miss Thomas, our victim advocate is Iman Cheney. If you reach out to her, she'll be able to give you additional information.
She said I wasn't able to get a restraining order due to me not knowing the address of the victim. To the other person in this case. So that's the only thing where I can't get that. So I don't know how to obtain that so I can do my order.
I see Ms. Cheney has come on the screen.
Yes.
Hi, Ms. Cheney. Thank you for coming on. They are equipped, and Ms. Cheney is more than capable to provide you with the information and knowledge that you will need to make sure that you're fully protected, because that is our first concern, is that you not be a victim of any more incidents. And so, Ms. Cheney, do you have the correct information? And don't say anything about that right now. Are you able to chat Ms. Thomas your number to call you in the chat directly to her? Can you see?
She does have my information. Yeah, she does have my information.
So you have that, Ms. Thomas, Ms. Cheney's information?
Yes, ma'am, I do.
All right, if you would please give her a call after court. I think she may be, are you staying on for the rest of the court? Ms. Cheney wanted to
Yes.
call you.
Yes.
She will be in court with me for about another hour, maybe. If you could call her then, or leave a message or email her, and she can email you back as well. And she can give you some advice on any other things that you might need for your safety, okay?
All right, thank you, Your Honor.
All right, you're welcome. Good luck to you.
All right, position 5.
All right, this is 22 CR 00 6461A. Is it Scott Dunshee or Dunshee Scott? Which way do I have it backwards?
Scott Dunshee.
Okay, Scott Dunshee.
Yeah.
All right, you're charged with 1 count of battery family violence. The offense date is 9/22/2022. Pre-trial?
First arrest.
Okay. ASG Duncan?
Yes, Your Honor, this incident did begin on September 22nd, 2022, and continued into this morning at the incident location 1015 Linham Avenue Southeast, that's LINAM. In this instance, officers were dispatched to the location at about 11:45 p.m. where they encountered the victim in this case, and they observed Miss Paula Van Goes, Paula common spelling Van, common spelling Goes, GES, standing outside in front of the house crying with the doors open, and the defendant in this case standing inside the house yelling, Miss Van Goes, and she stated that the defendant is her boyfriend, and they have been living together for the past 3 years, and that he had been drinking all day and became verbally abusive towards her and eventually physically abusive towards her. She stated that at some point he became enraged because he believed that she was cheating on him, and he started destroying property inside the home. When she attempted to stop him from destroying the house, he grabbed her by the arms and started slamming her around the house, which caused a laceration on her forearm. Ms. Van Gogh stated that once he let her go, she went outside to call 911. She stated to officers that he has hit her several times before in the past, but she has been afraid to call the police to report it. And we did get a chance to speak to her this morning, and she did confirm that they are in a relationship, they live together, but they have no children. In addition, she stated that that day the defendant had drunk about 12 to 18 beers at the time of the incident, and he was going to get some more. She stated they do have a business together. However, given the concerns that the state has for this case and the risk of reoffense, as well as the intimidation based on the statements made to the police officers, even though this is the defendant's first offense, we're concerned about the allegations of continued abuse in this relationship. So we're going to be requesting a $3,500 surety. No further contact with the victim in this case, Paula Van Gogh, and stay away from the incident location, one-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. The victim in this case did state that she is possibly looking into filing a TPO. However, out of an abundance of caution and the fact that there's been a relatively no cooling off period since it ended this morning, the state would think that its recommendation is more than reasonable in this case. And I do believe that the victim is on the line if Your Honor would like to sound for her. Nothing further from the state.
Your Honor, you're on mute.
Yep.
I do see the victim on the line, Ms. Van Gogh and Ms. Gant. Would you like to go before or after?
The complaining witness can present, Your Honor, but I would ask that she just limit her testimony to whether or not she wants to have contact with Mr. Dunshee.
And the state would request that she be allowed to testify freely, given that it relates to the all factors in this case.
All right, I will let her testify to a little more than that, according to the Ayala factors. All right, Miss, is it Van Gogh?
Yes, it is. Thank
I
you.
didn't want to mispronounce your name. I need to swear you in if you would like to address the court.
Okay.
All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, go ahead and tell me about this incident.
This has been something over a 3-year relationship, has been escalating. And we have both been working on our mental health, and
Objection, Your Honor. If Ms. Van Gogh would like to testify regarding her mental health state, then we have no issue with that. However, my client, if he has his mental health issue, it's confidential.
And the state is just requesting that the victim continue to testify. I believe she's just giving context to what happened in this particular situation.
All right, let's do very limited information at this point regarding other issues that the defendant may have. So we don't want to violate any rights that he may have as far as confidentiality.
absolutely, my apologies, ma'am.
Okay.
He was sober for 9 months, and
Objection, Your Honor.
This is her firsthand knowledge, Your Honor. I believe she should be able to testify regarding the other factors in this case, as far as risk of reoffense and the intimidation in this case.
Tell me about the, okay, I have it, Ms. Gann, I've got your objection. Can you tell me just about the incident in question, which occurred on 9/21? What happened on that date?
yeah, he began to drink throughout the day. He was perfectly fine. Spoke with his I believe, ex-wife and son, and began to get more and more agitated throughout the day. Tried to calm it down, and I left the house because I saw his agitation was getting stronger. So I went to a local bar that we would frequent together, and I was there reading a book, and he came up behind me and was intimidating to me. I went inside to talk to the bartender to request that he not sell him another 6-pack of beer, which ended up with us in the other room and him intimidating and yelling at me, and then intimidating text messages. I came home and he was enraged, so I went out to the car to sleep, and he knocked on the window of the car and said he would leave me alone. I came inside, and then he just kept verbally abusing me and making accusations of things that I did not do, sexually related things that I did not do. So I went out to the car again to go to sleep. And then I saw him drive off. So once he had left the property, I went back into the house, and this is the point where I noticed that furniture was being removed, like televisions and personal property was being pulled apart. He came back and was very intoxicated and went to the shed in the backyard where his tools are, and he was insisting that he was going to pack up all of his things and leave. And I said that you are too drunk to drive. There is no point. You can go in the morning, just go to sleep. And at the point of saying go to sleep, then he started pushing me around and telling me how much he hated me and that sort of thing. And that was the point in which my arm got scratched. This particular instance did not warrant it. I got some bruises.
Objection, Your Honor, objection. It calls for speculation.
I think she's talking
The
about her.
speculation is the bruises on my body. There's no speculation.
Hold on, Ms. Van Gogh. All right, Ms. Gant, your objection is noted. I think Ms. Duncan was going to respond to your objection.
Yes, I was going to state for the court that the victim is speaking specifically about the actual injuries she received in this case.
Right. I will overrule the objection. Go ahead, Ms. Van Gogh. And I don't have a whole lot of time. This is not the trial. This is just for bond purposes. So let me ask you this: are you still, or are you in fear of Mr. Scott, or Mr. Dunshee, I should say?
When he is sober, he is perfectly fine. When he is drinking, he is not.
Okay.
I am scared of him when he's drunk.
Okay. And do the two of you still reside at the Lenham Road address?
He was intending on moving out this weekend.
Okay. But as of the moment, he has not moved out and still has belongings there. Is that correct?
Correct. His belongings have all been moved out to the shed. And he has access to that. I've changed the locks on the house.
And is this a purchased home or a rented home?
Purchased.
Okay, whose name is on the deed?
Mine and my ex-husband.
Oh, all right. That at least tells me what I need to know. And you are still in fear of him. Is that correct?
Mildly, yes.
Mildly. Okay.
Yes.
All right. Go ahead, Ms. Gant.
Thank you, Your Honor. Mr. Scott Dunshee is 48 years old. He has been in the Atlanta area for 3 years. He does not share any children with complaining witness, but he does have two children, ages 16 and 21. He is paying child support for the minor child. We are unopposed to the stay away. My client does not want to have any contact with Ms. Van Gogh's. We are requesting a one-time law enforcement escort so that he may retrieve his belongings from that residence, which it appears that Ms. Dunshee has illegally evicted him, Your Honor. Mr. Dunshee completed high school. He informs me that he is employed in construction and has been so for the past 3 years. This is a 48-year-old gentleman. He has never been arrested, no prior convictions whatsoever for violence or anything in that regard. He denies the allegations. He denies being drunk. He states that he had been working and he wanted to end the relationship with Ms. Van Goes. He came home to try to pack his belongings. She became upset, started throwing things around. She's upset that he is moving on without her. He states that in the process of gathering his belongings, which she even stated, she came toward him, he pushed her away just to get her away from him to de-escalate the situation, Your Honor. I'm requesting a signature bond on Mr. Dunshee's behalf. Again, he has no prior arrest or any convictions for violence, Your Honor. We are unopposed to the no contact and the stay away orders, and we would again request that one-time law enforcement escort. Thank you, Your Honor.
Okay, I know Ms. Gantt, you said that Mr. Dunshee was, 48 years old. What type of work did you say that he did?
He is self-employed. He owns a construction company.
I believe that may be a company that they own together. Is that what you were going to say, Ms. Van Goes?
Correct.
That is a company that he owns jointly with the victim in this case. And that was a concern. However, for the interest of our safety, we're going to right now ask for no further contact, and then the division of the company or the assets can be handled at a later date.
Or a different type of action, obviously.
Correct.
Okay, I'm going to order a $4,500 surety bond. I'm going to order that there be no further contact with the victim, Paula Bengals. I think, let me step back for a second. Are you both running this business together and are going to have a need come, Monday or Tuesday to be around each other at this business, or is it something that you can run and not have to have contact? Because I'm concerned, about that.
Your Honor, I do need to have a conversation on the status of 2 projects. I believe they are projects that I can either return the money to the client or complete one of the other projects with some assistance. The other larger project, in which we do have a contract, we are 50% owners for the company. We are waiting on a permit from the city, and I'm not sure when the permit comes through, who will be able to complete the work.
All right. ASG Duncan, with that in mind, and I know that obviously will be a civil matter, but I certainly want to make sure, Ms. Bengals, that you're safe and that you are not subjected to any other incidents, and also that I wouldn't put you into a position as a victim to where you may be subject to any other incidents. I only want to make sure that you're going to be safe. And there hasn't really even been the cooling off period either, because it just happened. And I know that Ms. Gant said that he's intending to move out, but you have put his things in the shed. Do you run the business from home, or is there a business location?
It's run from home. A friend of ours, a mutual friend of ours, has offered to be an intermediary so that we could pass information back and forth to avoid personal contact.
Okay, that is good information to know. So with this $4,500 surety bond, I'm going to order, as I stated before, no further contact between the two of you. And if Ms. Gant needs to apply for a bond modification later, she can do that. I'm going to order that he stay away from 1015. I don't know if it's Linham or Linham Road Southeast. He will get a one-time law enforcement escort to return there to retrieve his items. Even though those items are in the shed obviously is on the property. So, Mr. Dunshee, you're not to return back to retrieve your items until you have a police escort, even though they may be in the shed that's outside of the main home. But it is for the safety of the victim in the case. So please do not return until you have a law enforcement escort, and you are to stay away from that location. No drugs, alcohol, or weapons while on bond. And I think that will conclude all that I'm going to order at this time.
Your Honor, am I to understand that you are ordering third-party business contact at this time?
No, and I meant to say that when Ms. Van Gogh stated that there is a third party that can help them with these business transactions. And I'm saying no further contact and to stay away. So he can't contact her about business, about personal things or anything. But if there needs to be contact, unless you want me to put it in the order specifically, that any business contact regarding the business that you run together, those conversations should be facilitated through the third party. And do you want the third party's name to be mentioned or any other third party that you may choose, Ms. Van Gogh?
Any other third party.
Okay.
To reduce complications.
Okay, so we'll just say any other third party, they can relay messages through regarding the business deals that they have or resolving those business deals so that again, he doesn't violate the order nor do you as far as no contact with each other.
Correct.
All
And
right.
just one more clarification for the record. My apologies, Your Honor. It's 1015 Lynham Avenue Southeast.
Did I say, I may have said the address wrong, 1015 Lynham Road Southeast?
Lynham Avenue.
Avenue, okay. All right, Avenue.
And Judge Mency, if I may, I do apologize for interrupting. I would ask that Your Honor reconsider the ruling regarding the surety bond. Mr. Dunshee, again, is 48 years old. He has no prior history. He's recommended for a surety bond, for a signature bond, Your Honor.
And again, I would ask that Ms. Gant and the defense respect Your Honor's ruling, given the facts and circumstances in this case. I think Your Honor's ruling should stand. Nothing further from the state.
I understand he may be recommended, but based on the facts and what I've heard, I am going to deny the request or the recommendation for a signature bond this time. I'm going to keep it to the surety bond. It seems like he may obviously have the means to be able to pay for that 10% of that, 13% of that bond. So I'm going to leave it at the $4,500 surety bond.
Thank you, Your Honor.
Thank you, Your Honor.
All right, you're free to go, Ms. Van Gogh.
Position 4, Cornelius.
This is 22 CR 006455C, Alvin Cornelius. You're charged with 1 count of simple battery against a police officer, police dog, corrections, or detention officer. And the second charge of marijuana possession less than an ounce. Both offense date September the 22nd, 2022. Pre-trial?
7 total. Last arrest was 2016. Criminal sale of marijuana, 4th degree. Unlawful possession of marijuana. He was convicted for disorderly conduct. Before that was 2009, aggravated harassment, telephone. And before that was 95. That was the New York history. He also has history out of, is it North Carolina? But that was from the 90s. He's a resident of Staten Island, New York.
I asked you, Duncan.
Yes, Your Honor, this incident did occur yesterday at the Lakewood Amphitheater at 2002 Lakewood Way, Southwest in Atlanta. In addition to what pretrial has stated, I did know in my research that the New York history did indicate that there was an open bench warrant on file that gives the state some concern about this defendant being a flight risk while on bond. And we also see that a majority of his criminal history is out of the state of New York. So we do have some concerns about the ties to the community, given that this defendant is a multi-state offender of Georgia, North Carolina, and the state of New York. In this incident in particular, the defendant in this case was approached by Deputy M. Walker of the Taliaferro County Sheriff's Office, that's TALIAFERRO, who was working an extra job, approved job at the Lakewood Amphitheater. He was dressed in marked clothing, and he had approached and made contact with the defendant in this case because the defendant was in possession of marijuana and in an area of the venue where security was attempting to clear out. The defendant continued to ignore the deputy's request and engage in verbal altercations with another patron of the facility. The defendant was told not to return to that area. He continued to do so. So the security at that time, Deputy Walker, did tell him to leave the facility. And when he chose not to leave the facility, Deputy Walker placed his hands on the back of the defendant to help guide him out of the facility. And at that time, the defendant grabbed a hold of Deputy Walker and would not let him go. I want to make it clear for the record, the warrant does indicate that physical contact by the defendant was not wanted by Deputy Walker at that time. So we do have some concern about the risk of reoffense in this case, given that this defendant does have history of similar offenses. And also our previous concerns about the ties to the community and the flight risk. And I do just want to clarify for the record that this defendant's jailing screen did appear to have 3 charges. However, there are only 2 charges, which are the 2 counts that are present before the court today. The 3rd charge is not an additional charge. It is actually the warrant for count 2 that is before the court today. So given the facts and circumstances surrounding this incident, this defendant's risk of reoffense while out on bond, the state is requesting that the preset bond of $1,500 surety remain as set, and that breakdown is 1,000 surety for the simple battery against a police officer and 500 surety for the possession of marijuana. We ask that the defendant stay away from the Lakewood Amphitheater, that the defendant have no further violent contact with the officer involved in this incident, that there be 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, PD Gant.
Thank you, Your Honor. Mr. Alvin Cornelius is 51 years old. He is a native of New York, resident of Staten Island. However, he does have family in the Atlanta, Georgia area, Your Honor. He was here for a concert. He states that he's married for 32 years. He has children ages 30, 28, and 25. He is considering relocating to the Atlanta, Georgia area. We are unopposed to the stay away at the incident location. Mr. Cornelius completed the 11th grade and he is unemployed at this time. He strongly denies the allegations. He informs me that he did not know who the officer was. He recalls being approached and he thought the situation was resolved. The next thing he knows, the sheriff is approaching him, taking him away without telling him why. I do acknowledge my client's history. However, Your Honor, it is remote. The last arrest was 2016. That from the report that I received that says out of Fulton County, Georgia. However, I did not see that charge listed in Odyssey, Your Honor. I am requesting a signature bond on Mr. Cornelius's behalf. And if Your Honor determines that he is ineligible, then I would ask for a bond reduction of no more than $1,000. And that would be $500 for the simple battery and $500 for the marijuana less than 1 ounce. Thank you, Your Honor.
All right. I'm going to order a $1,500 surety bond, 1,000 on the simple battery, and 500 on the marijuana charge. With that 1,500 surety bond, no drugs, alcohol, or weapons. And a stay away, yes, from 2002 Lakewood Way. What is that location? Does anybody know?
The Lakewood Amphitheater.
Oh, that's right, you did say that. Let's have him to not go back there for any shows or concerts at this point. And no further contact with the Deputy M. Walker. And I think that should be it for my ruling. Anything else?
Nothing from the defense. Thank you, Your Honor.
Nothing further from the state.
All right.
Oh, excuse me, is Gail on that?
Did you say?
Mr. Cornelius, remain silent. Ms. Irwin is on the phone. I have been in contact with her.
All right. Yeah, so you say 1,500 ag, but
Mr. Cornelius, I will reach out to Gail Irwin, and she is also on this Zoom call. She is aware of what's going on. Do remain silent, please.
Who's next?
I apologize, Your Honor.
You got position number 8, Mr. Lucas, Diedrich Lucas, 8.
This is 22 CR 006456C. Diedrich Lucas, you're charged with 1 count of battery family violence, offense date March the 19th, 2022, pretrial.
18 total. Last arrest was in April. Battery DV. It's open. 22 CR 002310C. 2019 probation theft by taking. 2019 probation ag assault. 2019 giving false name conviction. Misdemeanor terrorist threats conviction, obstruction conviction. That's all one arrest. 2016 felony theft by taking conviction. 2014 battery DV, 2 counts, 1 count cruelty and a third. Before that was a 07 disorderly conduct conviction. That's all.
Your Honor, as it relates to Mr. Lucas, on March 19th of this year at 1985 Lathrop Street, officers met a young man who stated that his mother and father were in a fight. Officers did make contact with Miss Priscilla Phillips, who was loading clothes into an SUV. Officers observed that Miss Phillips had a swollen lip and saw a large amount of blood on the floor near the front door. Miss Phillips stated that the blood came from her lip and that she was scratched on her arm as well. Ms. Phillips stated that the disputes are a regular occurrence and that she didn't want to move forward because she already had a police report out on the defendant in this particular case. Ms. Phillips then stated that the defendant struck her on or about her body and her lip. Defendant, as already indicated by pretrial, does have an open family violence battery, and I believe that is 22 CR 002310C, and that is currently before the Honorable Judge Dixon. That, from my understanding, that event took place February 21st, 2022, against the same victim, and a $3,000 surety bond was given during that incident, and a special condition that there be no further contact with Ms. Priscilla Phillips. And as indicated, that did precede this particular incident, Your Honor. Okay. In addition to that, the defendant does have an open aggravated assault here in Fulton County. That is 22 CP 208-282. And that incident took place April 14th of 2022 against the same victim. During that incident, he received a $25,000 surety bond with a special condition that he have no further contact with Ms. Priscilla Phillips. Now, that particular incident, Your Honor, took place after this incident. It was already indicated that the defendant does have 18 cycles. Convictions over the last 10 years include, as already indicated, the theft by taking out of DeKalb County in 2016, given false name in 2019 in Fulton. The defendant did complete first offender sentence for aggravated assault, family violence, and family violence battery and cruelty to children against the same victim. 2019, there was a probation violation in both Fulton and DeKalb, and the defendant was arrested for family violence battery in 2018. However, that case was later dismissed. Your Honor, at this time, we're asking for a $3,000 surety bond, a stay away from the incident location, 1985 Lathrop Street. No further contact, again, as a special condition with Ms. Priscilla Phillips. No alcohol, drugs, or weapons. 12 weeks of domestic violence intervention program at the defendant's own expense. We do believe that the defendant poses a significant risk to reoffend and intimidate the victim in this case. Given his open cases involving the same victim, this is teetering on the line of possibly becoming felonious activity. And we're asking that you go with the $3,000 surety bond. Thank you, Your Honor.
All right, thank you. PD Kim?
Yes, Your Honor. Mr. Dedrick Lucas is 45 years old, Your Honor, and he was born and raised here in Georgia. This incident is kind of like another hit after he was already arrested and paid the price on April 17, 2022. He was very shocked that this came up again after that arrest. Apparently that arrest was for February 21, and this is for March 19. We just wish that it was all handled at the same time. And yet he has to be arrested again. And he just feels like it was kind of sudden and kind of surprising. This happened before April 14, April 17, where there was no further contact or stay away order. He now resides at a completely different address in Decatur. He does not live with his Priscilla Phillips, a wife who has 9 children with him. And he understands that the importance of no further contact until all these gets resolved. So we would like to request for a signature on bond for this old issue, since he's already having $25,000 surety bond and $3,000 surety bond for same kind of offense. He has 6 minor children, Your Honor, that he has to support financially. They have a total of 9 children. That's a lot of kids. And he's been waiting. I mean, he's been like unemployed for last 2 months because of arrest and being incarcerated. And he wants to get the job to take care of his children. And he has been actively interviewing, and now he has a drug test. He's waiting for drug test. And if he passes that drug test, he will be able to get a job. So he needs another chance. And he has completed up to 11th grade. And we would like to request for a signature on bond for this matter. Thank you, Your Honor.
Your Honor, if I may briefly, we do agree with the defense as it relates to the subsequent events in April. However, that does not negate the fact that on February 21st of 2022, he was given a special condition of no further contact order for Priscilla Phillips then. And even after that, he still made further contact. And not only did he make contact, that contact was violent in March, and that contact was violent in April. And so based on
that, the February 21, 2022 incident, he was arrested on April 17, and that no further contact order was after April 17, Your Honor. So on March 19, he did not have those orders at the time. I don't think it is right, but it's not like there was no order at that time.
Okay. And I'm following you with the other incidents and the lack of orders. But given that, I'll order the $3,000 surety bond. No drugs, alcohol, or weapons while on bond. Stay away from 1985 Landrum Road. And what else? Oh, no further contact with the victim. Give me that name again.
Priscilla Phillips.
And is there anything else council we need to take up?
Yes, we would like to request
Matthew.
a third-party transfer child visitation. He has 9 children. I mean, 6 of them are minors. And I believe that his wife, Priscilla, was gonna be on the Zoom to tell the judge that she actually want to modify the bond condition to allow contact.
Well, at this point, I'm gonna order no further contact. And I did not hear, or I may have missed that, Ms. Kim, are they still residing in the home together?
Nope, not anymore.
Okay. No further contact. I did stay away from the 1985 Landrum, just to be on the safe side. But I guess there's nothing else that I need to take up, and no drugs, alcohol, or weapons, so while I'm bond.
Thank you, Your Honor. And I would, just for the record, Your Honor, I do stand corrected. It does look like the February 21st, 2022 event, I look further at that, the arrests were not made until April. So, but I do stand by my recommendation, given the number of cycles, the open cases, and things of that nature. So thank you, Ms. Kim, and thank you, Judge.
All right, thank you.
So we have.
Oh, I'm sorry, I forgot about the third-party transfer of the child.
Yes, thank you.
To add
No
that.
objections, Your Honor.
Okay, good.
Yeah.
Shania Matthews, come on, Mr. Matthews. Have a seat now.
Which number is this, Deputy?
This Shania Matthews.
All right, this is 22 CR 006458F. Dwight Matthews, you're charged with 1 count of battery, family violence. Offense date is August 16th, 2022. For your child?
This is, hold on. This is 10th arrest. Last arrest was in January, failure to appear. I got an open battery DV 20 CR 001999F. Another open battery DV 21 CR 002017F. Let's see what else. 2022 January, failure to appear for battery DV, Franklin County. 2020 battery DV, misdemeanor possession of marijuana. Before that was 06, possession of a controlled substance conviction. And before that was in the 90s.
Okay. All right, DSG Rhodes.
Yes, Your Honor. As it relates to Mr. Matthews, on August 16th at 1215 Westview Drive, Ms. Tamara Robinson stated that she and the defendant, her ex-boyfriend, whom still lived together, were in a verbal altercation. The defendant began striking her in the face with his fist, causing her lip to split and bleed. Officers observed a knot above her right eye and swelling laceration to her upper lip. When Ms. Robinson went to call 911, the defendant took her phone and broke it. Ms. Robinson waited until the defendant took the children to school, and that's when she was able to call 911. Ms. Robinson told police that this is not the first physical altercation in the 5 years they have been together. As already indicated, the defendant does have 10 cycles. There's been no convictions in the last 10 years. However, one of his last convictions was in 1997 for battery in DeKalb County. I believe that pretrial did indicate that there was a 2019 probation violation in both Fulton and DeKalb. And as indicated, the defendant currently has 2 open cases with the same victim for family violence battery before Judge Morrison here in Fulton County, and they are 20 CR 001999F and 21 CR 002017F. On each of those, on 2 separate incidents, the defendant was given a $2,500 surety bond and a no further contact with Ms. Tamira Robinson. And that was on each, Your Honor. So on this case, what we're asking is for a $4,500 cash bond and no further contact with Tamira Robinson. Stay away from 1215 Westview Drive. No alcohol, drugs, or weapons. 12 weeks domestic violence intervention program at the defendant's own expense. We do believe that the defendant does pose a risk to reoffend, and we believe that he possesses the capacity to intimidate the victim in this particular case. This is another case, Your Honor, which might very well result in felony charges given the 2 open cases. Thank you, Your Honor.
Your Honor, my client is 66 years old. He is a lifelong resident of the state of Georgia. He tells me that he is disabled and has been disabled for the past 13 years. So he has very little income because all of his income comes from his disability. He vehemently denies the allegations, Your Honor. He says they're absolutely untrue. He has not put his hand on the complaining witness at all, who is, she is significantly younger than he is, Your Honor. They do not share any children together. She has been the one who keeps coming back to his home over the years that they have been in a relationship. She is the one who refuses to stay away from him, Your Honor. She comes there, causes problems, and then she leaves and she goes and she complains and she makes up stories. My client, any history that my client has is remote, Your Honor. Yes, there was a conviction, but that was in 1997. That's an adult lifetime ago. So I would ask the court to take that into consideration in setting a bond for him, his circumstances, the remoteness of any history that he may have, and the fact that he does deny the allegations, Your Honor. Thank you.
Your Honor, very briefly, I would just respond that while the defense's allegation that the offenses were made up, I would just remind Your Honor of the factual basis of the injuries that the officers observed while on scene, of the busted lip and the knot above the eye. I don't think that the officers made those up. Thank you, Your Honor.
What was the victim's name again? Can you all hear me?
He's muted.
Hmm?
He's muted.
Oh, I'm sorry, Mr. Rhodes, you're muted.
Thank you, Your Honor.
All right.
First name is Tamira, Tamirah, and the last name is Robinson, spelled the traditional way.
Okay. All right. And so they are still or not, do we know, in a relationship?
They are not in a relationship, Your Honor, and haven't been for at least 2 years, according to my client.
According to Ms. Robinson, they were ex-boyfriend and girlfriend who were still living together. That's correct.
Okay. All right. I'm going to order the $4,500 surety bond. I'm going to order no further contact with the victim, Tamira Robinson, and I'm going to order a stay away from 1215, is it Westview Drive.
That is correct, Your Honor.
And a stay away, no drugs, alcohol, or weapons while on bond. Anything else I need to take up, counsel?
Your Honor, just for clarification, was that 1215 Westview Drive?
I believe.
Yes, Your Honor.
Yes. That
Thank you.
is correct. Thank you.
All right, Judge, we're completed here in courtroom 2.
All right. Have a good weekend.
You too, thank you.
Thank you.
Thank you so much.
All right.
Thank you, Judge.
Mr. Rhodes, is this your first C calendar with me?
Well, I was on a couple of times actually just supervising, but this is the first one where I got to speak. So
Good. They let you speak. Very good. All right. We'll reconcile in a few minutes. Hold on 1 second. Yes, ma'am.
Position number 1, $3,000 pretrial bond per judge. Position number 2 is a $3,000 good bond, reset 10/6 SAP. Position number 3 is a $2,000 good bond, reset date 10/6 SAP. Position number 4 is a $1,500 good bond, reset date 10/6 SAP. Position number 5 is a $4,500 good bond, reset date 10/6 SAP. Position number 6 is a $5,500 pretrial bond, reset further notice. Position number 7 is a $5,000 good bond, reset 10/6 SAP. Position number 8 is a $3,000 good bond, reset 10/6 SAP. Position number 9 is a $4,500 good bond, reset 10/6 SAP. Position number 10 is a $1,500 SOP through the jail, reset further notice. Position number 11 is a $7,000 split, reset 10/6 SAP. Any questions or concerns?
I think that is correct. Anyone else? No. All right, everyone. Have a good weekend. We'll see you next time. All right.
Same to
weekend,
you, Judge.
everybody.
Thank you.
All right. Thank you. Bye-bye.